We have breaking news. The U.S. Supreme Court has blocked the Trump administration from deploying the National Guard in Illinois. In a 6-3 decision, the Supreme Court ruled they will not allow the White House to deploy National Guard troops to the Chicago area as a legal challenge moves forward. CBS News immigration and politics reporter Camila Montoya-Galvez joins us now. Camila, what did the justices say in this decision? And is this sort of a stay or is this on the merits?
Well, to justify his attempts to deploy the National Guard to Chicago, Portland, and Los Angeles and other cities across the country, the President Lindsay has argued that violent protesters are obstructing and interfering with federal immigration operations, including by ICE and Border Patrol, and that the National Guard is needed in these Democratic-led cities to protect immigration agents and also facilities where detainees are held.
Hey friends, Adam here. So let's get started. The Supreme Court just ruled 6-3 that Trump cannot federalize state National Guard troops and deploy them into American cities as his personal street patrol, and conservatives he put on that bench were in the majority. The court didn't just say no. They went further, stating explicitly that continued defiance of court orders could result in incarceration, not fines, not political embarrassment, actual jail time.
Well, when it comes to shrill political invective, the fur has been flying in all directions here this week. After Donald Trump sent the troops in, the state's Democratic Governor J.B. Pritzker decried it as an illegal invasion. Trump then in turn called for him to be locked up and for Chicago's Democratic mayor to be locked up. Then we got that really significant intervention in the courts yesterday, with a judge pointing out that there was no credible evidence of a rebellion in the state of Illinois and therefore no need for the troops. What we're seeing here across America is this epic struggle between presidential power and state sovereignty being played out in these big Democratic voting cities. And the message from the Democrats, the boast of the Democrats in this one now is, if Congress won't check this president's power, then Chicago will.
The word being whispered through every corridor of power in Washington right now is one Trump has never had to take seriously before. Let that sink in for a moment, because it's almost impossible to process. The President of the United States is being formally threatened with personal imprisonment by the judicial branch of his own government. We're not discussing some hypothetical scenario from a political thriller novel. This is the actual legal reality confronting Donald Trump at this precise moment in history.
In this case, specifically focused on the Chicago area attempted deployment, the majority of the High Court has said that the Trump administration actually did not meet the requirements in the federal law it cited to justify the deployment of the Guard there in Illinois. The majority of the court said, and I quote, "Before the president can federalize the Guard under the relevant statute, he likely must have statutory or constitutional authority to execute the laws with the regular military and must be unable with those forces to perform that function."
The $355,000 in fines that have already accumulated against him represent the warning shots, the judicial equivalent of a police officer tapping on your window and suggesting you slow down. But the court has now made it unmistakably clear that the next round of ammunition won't be financial. The next round will be aimed directly at his physical liberty.
Donald Trump could be facing jail time if he continues to violate his gag order. That's according to the judge who is presiding over his hush money criminal trial in New York.
During today's hearing, we heard from a former executive with the Trump Organization who worked closely with the company's financials. Fox 5's Michelle Ross has the details from outside the courthouse.
There were two witnesses on the stand today, both long-term employees of the Trump Organization who went over financial documents for the jury. Now, as for the gag order, $1,000 per violation likely doesn't cause much of a dent to a billionaire's pocket, which is also probably why the judge is mentioning jail time.
And for a man who has spent his entire adult life building an empire on the foundation of never facing genuine consequences, the prospect of actual incarceration represents the ultimate nightmare scenario. The question that immediately arises from this stunning development is obvious. How did we arrive at this precipice? How does a sitting American president find himself staring down the barrel of potential jail time for defying the very court system he swore an oath to defend?
Judge Juan Merchan threatening jail time for Donald Trump after fining the former president for the 10th time because he violated his gag order again.
He's taken away my constitutional right to speak.
The fine payments now totaling $10,000, but the judge says it's clear the $1,000 fines aren't working. Judge Merchan adding, "The last thing I want to do is put you in jail. You are the former president of the United States and possibly the next president as well. As much as I don't want to impose a jail sanction, I want you to understand that I will if necessary and appropriate."
The answer reveals more about Trump's fundamental approach to power than any campaign speech or policy document ever could. Trump has been operating under an interpretation of presidential authority that bears little resemblance to the Constitution's actual text or historical application. His legal team has advanced arguments claiming virtually unlimited executive power during times of perceived disorder or emergency. They've asserted that the president possesses near-monarchical authority to deploy military forces domestically based solely on his personal assessment of what constitutes a threat. They've essentially argued that when the president declares something an emergency, the normal constitutional constraints simply dissolve like morning fog. The Supreme Court just explained, in the most forceful terms available, that this understanding of executive power is not merely wrong, but dangerously wrong. The Insurrection Act, that dusty piece of legislation from a bygone era that Trump attempted to weaponize for his urban deployment scheme, contains specific requirements that cannot be wished away through sheer force of presidential will. It demands actual evidence of insurrection, not protests, not civil unrest, not even serious riots that local authorities struggle to contain. It requires something approaching armed rebellion against legitimate governmental authority. And the court looked at the factual record Trump's team presented and concluded, with 6 votes including conservative justices, that no such evidence existed. The entire legal justification for the National Guard deployment simply evaporated upon contact with judicial scrutiny. What makes this particular loss so devastating for Trump isn't just the ruling itself, but the unmistakable pattern it reinforces. This represents the 4th major Supreme Court defeat Trump has absorbed in a single term. 4 times he has walked into that courtroom believing his interpretation of presidential power would prevail. 4 times he has walked out having been told that his understanding of the Constitution is fundamentally flawed. The tariffs got struck down. Birthright citizenship modifications got rejected. Immunity claims got denied. And now the National Guard deployment lies in constitutional ruins. Each loss builds upon the previous ones, creating a legal record that future courts will cite for generations when defining the proper boundaries of executive authority. Trump isn't just losing individual cases, he's losing the war over what the presidency itself actually means. The conservative justices' participation in these defeats adds a layer of political devastation that no amount of Truth Social posting can undo. When Trump appointed these judges, when he campaigned on transforming the federal judiciary, the implicit promise was that conservative courts would protect conservative presidents. That's not how the judiciary is supposed to work, but it's undeniably how many Trump supporters understood the transaction. You give us conservative judges, we give you legal protection. Yet here we are, watching those very same conservative appointees join opinions that systematically dismantle Trump's most ambitious assertions of presidential power. They're not protecting him. They're constraining him. They're not enabling his agenda. They're declaring significant portions of that agenda unconstitutional. The cognitive dissonance this creates for Trump's political base cannot be overstated. The very judges they celebrated confirming are now the judges telling their preferred president that he has exceeded his constitutional authority. The unsigned nature of the court's ruling carries its own significance that deserves careful attention. When the Supreme Court issues an unsigned opinion, particularly in a case of this magnitude, it typically signals broad consensus among the justices about the fundamental principles at stake. They may disagree about peripheral details, but on the core constitutional question, they stand united. In this instance, the core constitutional question was whether a president can unilaterally federalize state National Guard units for domestic deployment based on a self-determined assessment of insurrectionary conditions. 6 justices said no with sufficient force that the remaining 3 couldn't prevent the ruling from issuing. That's not a close call. That's not a contentious 5-4 split where legal scholars will debate the reasoning for decades. That's a decisive rejection of presidential overreach that leaves minimal room for future presidents to attempt similar power grabs. Now let's address the element of this story that has every cable news producer working overtime and every White House staffer updating their resume: the jail threat. Those 2 words sound like hyperbole, like the kind of exaggerated rhetoric that political commentators deploy when they want to generate clicks and views. But in this specific context, the threat of incarceration emerges directly from established legal principles that courts apply every single day to ordinary citizens who defy judicial orders. Contempt of court is not some exotic legal concept reserved for extraordinary circumstances. It's the mechanism by which judges ensure that their rulings carry actual weight in the real world. When a court issues an order and the recipient of that order willfully refuses to comply, the judge possesses the authority to hold that person in contempt. And contempt, unlike many legal consequences that wealthy and powerful individuals can navigate around, carries the genuine possibility of incarceration. The logic of coercive custody applies regardless of the defendant's station in life. A judge can order someone jailed until they comply with the court's directive. For ordinary litigants, this might mean sitting in a cell until they produce documents they've been withholding or answer questions they've been evading. For a president who defies a Supreme Court ruling about the limits of his military deployment authority, the principle remains identical even if the practical and political complexities multiply exponentially. The court has already imposed substantial fines, $355,000 worth of financial penalties that would devastate most Americans but barely register on Trump's balance sheet. The fines served their purpose as initial warnings, as demonstrations that the court was serious about enforcement. But the justices have now signaled with unmistakable clarity that the warning phase is concluding and the escalation phase is beginning. The next step on the escalation ladder is personal liberty, not corporate liability, not political consequences, individual freedom. The timing of this judicial explosion could not possibly be worse for Trump's broader political standing. This Supreme Court defeat lands in the middle of a perfect storm of converging crises that have already pushed his presidency to its most vulnerable point. The Epstein file controversy continues generating headlines that no amount of strategic distraction can suppress. The Bondi firing saga has exposed the chaotic dysfunction at the highest levels of his administration. Republican members of Congress have begun voting against his military authorization requests, including the Iran strike authorization that would normally command near-universal GOP support. Impeachment discussions that once seemed like Democratic fantasy are now occurring in serious political circles with actual legislative implications. And through all of this turbulence, the polling numbers tell a story that even the most talented spin doctors cannot massage into positive territory. 62% of Americans now believe Trump defies court orders too frequently. That's not a plurality. That's not a narrow majority that could shift with the next news cycle. That's a supermajority of the American public expressing concern about a president's relationship with the judicial branch. When nearly 2/3 of the country agrees on anything in this polarized era, political professionals recognize that something fundamental has shifted in the public consciousness. The number transcends partisan affiliation and ideological commitment. It suggests that ordinary Americans, regardless of their voting history, have reached a collective conclusion that this president operates outside the normal constitutional boundaries that have constrained his predecessors. And his approval rating, sitting at a perilous 35%, confirms that this perception is translating into genuine political weakness. Presidents with 35% approval do not command legislative majorities. They do not intimidate potential primary challengers. They do not shape the political environment to their advantage. They survive from news cycle to news cycle, hoping that something changes before the next election renders their weakness permanent. The Republican fracture that accompanies these numbers represents perhaps the most politically significant development of this entire saga. Trump's own party has begun distancing itself from him in ways both subtle and overt. Congressional Republicans who once reflexively defended every presidential action are now carefully calibrating their responses. They're voting against his military authorization requests. They're expressing public concern about his court defiance. They're creating political distance that will serve as insulation if the legal situation continues deteriorating. Nancy Mace's formal letter criticizing the administration's handling of sensitive matters exemplifies this shift. When Republican members of Congress put their concerns in writing, when they create documentary evidence of their disagreement with presidential actions, they're not merely expressing momentary frustration. They're building a record that will protect them if the entire enterprise collapses. They're ensuring that future opponents cannot accurately claim they were silent in the face of constitutional overreach. The Republican calculation here is coldly rational and utterly devastating to Trump's political position. Every member of Congress faces re-election pressure. Every senator considers their future electoral landscape. When a president's approval rating sinks to 35% and a clear majority of Americans express concern about his respect for constitutional constraints, supporting that president becomes politically dangerous rather than politically advantageous. The same dynamic that once compelled Republicans to defend Trump, the fear of primary challenges from his loyal supporters, now pushes in the opposite direction. Defending a president whom most Americans believe defies courts too often becomes a liability in general elections. And for Republicans in competitive districts or states, general election viability matters more than primary purity. The political mathematics have inverted, and Trump finds himself on the wrong side of the equation. The legal momentum has also shifted decisively against Trump in ways that extend far beyond this single Supreme Court ruling. 4 major losses at the highest court in a single term establishes a pattern that lower courts will notice and follow. When the Supreme Court repeatedly rejects expansive claims of executive authority, federal judges throughout the country receive a clear signal about how they should evaluate similar claims that reach their courtrooms. The judicial branch operates through precedent and hierarchy. The Supreme Court sits at the apex of that hierarchy, and its repeated rejection of Trump's constitutional arguments creates a gravitational pull that affects every pending case and every future filing. Trump's legal team cannot credibly argue that lower courts should accept interpretations that the Supreme Court has already rejected. They cannot claim that the weight of judicial authority supports their position when the highest judicial authority has ruled against them 4 times in rapid succession. This legal momentum carries practical consequences for Trump's remaining agenda. Every executive action that pushes constitutional boundaries will now face enhanced judicial skepticism. Every claim of emergency authority will be measured against the standards articulated in these Supreme Court rulings. Every attempt to expand presidential power will confront a judicial branch that has already demonstrated its willingness to enforce constitutional limits regardless of partisan alignment. The courts have effectively announced that they will not serve as rubber stamps for presidential ambition. They will not defer to executive branch interpretations simply because the executive branch insists on their correctness. They will examine the actual constitutional text and the actual factual record and render judgment accordingly. For a president whose governing style depends heavily on pushing boundaries and testing limits, this judicial posture represents a fundamental constraint on his operational freedom. The National Guard deployment that sparked this constitutional confrontation deserves examination on its own terms, because it reveals so much about Trump's conception of presidential power. His proposal involved federalizing state National Guard units, removing them from gubernatorial control and placing them under direct presidential command, then deploying them into major American cities for street patrol duties. The stated justification invoked the Insurrection Act, that emergency provision designed for genuine rebellions against federal authority. But the factual predicates simply didn't exist. There was no armed insurrection in Chicago. There was no organized rebellion against federal law that state authorities had proven incapable of suppressing. There was urban disorder, certainly. There were protests that sometimes crossed into property damage and civil disturbance. But the gap between those conditions and the statutory requirements for invoking the Insurrection Act was vast and unbridgeable. The Supreme Court recognized this gap immediately. The justices understood that allowing a president to deploy military forces domestically based on such an expansive interpretation of insurrection would fundamentally alter the relationship between federal and state authority. It would permit any president of any party to federalize National Guard units and deploy them against any city whose local conditions the president deemed sufficiently disorderly. The potential for abuse was obvious and terrifying. Future presidents could use this precedent to deploy troops against political opponents, to suppress legitimate protest movements, to intimidate state and local officials who disagreed with federal policy. The court's decision to reject Trump's interpretation wasn't merely about this specific deployment. It was about preventing the establishment of a precedent that would permanently expand presidential military authority over domestic populations. The unsigned nature of the opinion reinforces this institutional concern. When the court speaks with one voice on constitutional fundamentals, it signals that the principle at stake transcends normal judicial disagreements. This wasn't conservatives versus liberals. This wasn't originalists versus living constitutionalists. This was the entire court, or at least a decisive majority spanning ideological divisions, recognizing that the constitutional order itself was threatened by the asserted presidential power. The opinion's lack of individual authorship suggests that multiple justices contributed to its reasoning, and that no single justice wanted to claim credit or accept blame for what was ultimately an institutional statement about the limits of executive authority. The jail threat that accompanies this ruling emerges from the same institutional imperative. Courts cannot function if their orders can be ignored without consequence. The entire edifice of judicial authority rests on the assumption that parties will comply with court rulings even when those rulings disfavor their interests. When a party demonstrates willingness to defy court orders, the judiciary must escalate its response or accept the erosion of its constitutional role. The fines imposed on Trump represented the first escalation. They signaled that the court was serious about enforcement and would not accept mere rhetorical compliance. But fines have limits as enforcement mechanisms, particularly against defendants with substantial financial resources. A defendant who can absorb financial penalties without meaningful hardship is a defendant who may calculate that defiance is cost-effective. The next available escalation is contempt and the coercive custody that contempt authorizes. The prospect of a sitting president facing incarceration creates constitutional questions that no court has ever had to resolve. Can a president be jailed while still holding office? Would the Secret Service accompany him to a cell? Would the 25th Amendment become relevant if a president were physically incapable of discharging duties due to incarceration? These questions have never been answered because no previous president has pushed constitutional boundaries to the point where they became relevant. Trump's willingness to test limits has created a situation where these previously theoretical questions may require practical resolution. And that resolution, whatever form it takes, will establish precedents that constrain every future president regardless of party or ideology. The public reaction to these developments confirms that something fundamental has shifted in American political consciousness. 62% of Americans believing the president defies courts too often represents a remarkable consensus in an era defined by partisan division. This isn't a Democratic talking point that half the country rejects. This is a broad-based perception that crosses demographic and ideological lines. When nearly two-thirds of the public shares a concern about presidential conduct, the political system responds. Members of Congress notice. Potential primary challengers calculate. Donors reassess their commitments. The entire ecosystem of political support that sustains any presidency begins to recalibrate based on this new information about public sentiment. Trump's 35% approval rating compounds the political damage. Presidents with approval ratings in the mid-30s possess minimal political capital. They cannot pressure reluctant legislators. They cannot intimidate potential opponents. They cannot rally public support for controversial initiatives. They operate from a position of weakness that colors every interaction with every other political actor. When Trump demands loyalty from Republican members of Congress, he's demanding it from politicians who recognize that his approval rating suggests electoral vulnerability. When he threatens primary challenges against dissenters, he's threatening politicians who have calculated that his endorsement may carry less weight than it once did. The political foundation that sustained Trump through previous crises has developed cracks that grow wider with each adverse development. The impeachment discussions that have emerged from this environment represent the logical culmination of these converging pressures. Impeachment is fundamentally a political process dressed in legal language. It requires political will more than legal justification. When a president maintains strong approval ratings and unified party support, impeachment efforts collapse regardless of the underlying factual record. When approval ratings crater and party support fractures, impeachment becomes viable regardless of whether the legal case differs substantially from earlier periods. The same conduct that seemed unremarkable when Trump enjoyed 45% approval becomes constitutionally concerning when he sits at 35%. The same court defiance that Republicans dismissed as political theater becomes genuine constitutional crisis when their own voters express concern about presidential overreach. Impeachment doesn't require new facts. It requires changed political circumstances. And the political circumstances surrounding Trump have changed dramatically. The Supreme Court's ruling on the National Guard deployment represents more than a single legal defeat. It represents a fundamental reassertion of constitutional boundaries that Trump has spent his entire presidency testing and transgressing. The court has declared, with 6 votes including conservatives, that presidential power has limits that courts will enforce. It has warned, explicitly and unambiguously, that continued defiance will trigger consequences beyond financial penalties. It has established a precedent that will constrain not only Trump, but every future president who contemplates similar assertions of executive authority. And it has done all of this at a moment when Trump's political standing is already at its lowest ebb, when his party is already fracturing, when the public is already expressing unprecedented concern about his relationship with constitutional constraints. The days ahead will reveal how Trump responds to this judicial rebuke. He may accept the ruling and abandon the National Guard deployment. He may seek alternative legal justifications that attempt to achieve similar outcomes through different means. He may escalate his rhetoric while complying with the court's order in practice. Or he may take the genuinely dangerous path of explicit defiance, forcing the judiciary to decide whether it will actually impose the incarceration it has threatened. Each possible response carries its own risks and consequences. Each path forward leads through territory that no previous president has traversed. And each choice Trump makes will shape not only his own political fate, but the constitutional inheritance we leave to future generations. What makes this moment genuinely historic is the convergence of legal and political forces that have created conditions for genuine accountability. The courts are enforcing constitutional limits. The public is expressing concern about presidential overreach. The president's own party is distancing itself from his most expansive claims. And the threat of personal consequences, actual incarceration rather than political embarrassment, has entered the realm of genuine possibility. This combination of factors has never aligned against a sitting president in quite this configuration. The outcome remains uncertain, as all political outcomes remain uncertain until they actually occur. But the trajectory is unmistakable. The momentum has shifted. The walls are closing in. And for the first time in his long career of escaping consequences, Donald Trump faces a convergence of forces that even his considerable talents for survival may prove insufficient to overcome. The Supreme Court has spoken. 6 justices have declared that the president exceeded his constitutional authority. The fines have been levied. The warning about incarceration has been delivered. The political support is eroding. The public is watching. And history is recording every development for the judgment of future generations. What happens next will determine not merely the fate of one presidency, but the durability of constitutional constraints on executive power in the American system. That's the stakes. That's the moment. And that's why this Supreme Court ruling represents something far more significant than just another legal defeat for a president who has accumulated many of them. It represents the system fighting back, and the system, for all its flaws and imperfections, appears to be winning.